Good evening, everyone. I guess this is the most interesting time of the day. It's because it's just before your tea. Well, we'll try to keep you awake. And with this interesting topic of DPDPA, I'm sure all of you are aware that DPDPA rules are out on the 13th of November, and every lawyer who's working on personal data is all excited in trying to see how to meet the 18-month timeline. Um, and also, in parallel, India has the AI guidelines that was passed, that was given to us by the ministry. Very interesting guidelines, more self governed guidelines. So we're going to try and talk about both these aspects over the next half an hour. I know five people in the next half an hour is going to be a challenge for me, of course, but the points that are going to be discussed are very interesting. Having said that, privacy as a fundamental right always existed in the Indian Constitution. But now we have a law called the DPDPA, which is the Digital Personal Data Protection Act, which gives empowerment to data principles. That's you and me. We have rights to exercise and obligations on data fiduciaries and companies to ensure they protect our data, they collect our data in a lawful manner, protect it with the right safeguards, and also have obligations flowing down to data processors to ensure our data is protected. So, with that, having said that, let's dive into our questions on the Act as well as the AI guidelines, which came out recently. My first question would be to Srinit. Srinit, right? We'll cover the Act first and the rules, and then we get into the AI guidelines. Well, with 18 months to go, Srinit, I think the regulators have given us 18 months to comply with the Data Protection Act. Must it be a policy first approach, or should it be a technology first approach? That's my first question. And you can follow up with what do you expect from the Data Protection Authority or the Data Protection Board to facilitate in this journey towards compliance?
Okay, let me get started with the first things first. When you said about the fact that whether it's going to be the policy first or it's going to be technology first, I think both have to go hand in hand. Policy will define what is required to be done. Technology would define how it's supposed to get done. I think all of us who are present here have abundant knowledge about the kind of policies that will have to be introduced or have already been introduced in a number of companies, whether it's privacy, whether it's grievance redressal, whether it's your data retention and erasure, whether it's your consent management policies, a number of others as well, including employee trainings. What's required to be seen or where technology would play a key role is about how these policies would actually get implemented. If the data has been retained, what's the technology, what's the process that being followed? And if that data has to be erased once the consent has been given or once the request has been made for the purpose have been achieved for which the data was collected, if that is automatically getting done. Similar work is for the consent management as well. So that's exactly where I think the legal team and let's say the DPO or the IT team would work together to ensure that the right policies are there and the right technology is there so that it becomes user friendly. And that's exactly where the employee trainings would also be very handy, because what needs to be done at this point of time, if God forbid anything goes wrong, it is not a policy driven by declaration. It's a policy or it's a framework which has to be proved to the adjudicating bodies or to the authorities or to the data protection board. And that is exactly why both have to work together. Come to the third question which you asked, what do you expect or what the companies would expect from the DPB? I think one of the first things will be explicit and absolute clarity. Things like significant data fiduciaries, things like reasonable security measures that have to be defined explicitly. I also have a board seat, and the first thing the board asks about are, what the repercussions penalties you're looking at? Oh, it's nothing much, it's just around 250 crores plus. And the moment you say that, at that point of time, they would want to understand what is the explicit security measure which I need to adopt to ensure that my company doesn't get prosecuted. And that is why an absolute clarity from DPB on a number of these similar aspects would be welcome. Secondly, as an industry, we would love if the DPB and other agencies actually conduct FAQs and sessions with different industries. Like I come from a manufacturing company, manufacturing, healthcare, IT, fintech. if those sessions are conducted with these, to ensure that going forward we understand what is expected out of us, so that voluntarily a mistake is not made. So that is something I think, because of the paucity of time, these are some things I would really appreciate clarity from the authorities.
Very good, important point that you brought out. That is the involvement of the regulators with the industry. I think that's key for the success of this act. So, Mr. Duggal, the next question is for you. With minimal or no obligations on the data processors, because most of the obligation or all the obligations is on the data fiduciaries in this act, do you see a challenge with the data processors aligning with the technology measures that is mandated by the rules and the nuances of the act? And especially in today's scenario where there are so many SaaS based providers and other outsourced providers, do you think that this would be a challenge to align with, or do you think the regulator should have gotten obligations onto the data processors to make life easier for the fiduciaries?
Well, ideally, the data processor, if he wants business, will have to ensure compliance with the DPDP Act and rules. The law is silent, but then primarily it's the data fiduciary who's responsible for all the compliances. Data processor is pretty much in an insulated space. But when I look at holistically the reading of the IT Act and of the DPDP Act and the DPDP rules, I'm very clear that the obligations of reasonable security safeguards will have to be adopted by data processors as well, because in any case they can also be potentially sued for 250 crore rupees in terms of fines, in addition to the data fiduciary per se. So I don't expect any running away. It would be far more better if there's more clarification. And I expect a number of clarifications coming in the next 12 months by the government on what needs to be defined as parameters defining reasonable security safeguards. You see, reasonable security practices and procedures are well defined under the IT Reasonable Security Practices Rules 2011. But I think with these safeguards being far more broader and covering elements like encryption and other stuff, which don't form part of the IT Rules 2021, more clarity is going to be required. And ultimately, the ecosystem is one and the same. Data fiduciary is not going to give business to the data processor if the data processor cannot indemnify the data fiduciary, and if the data processor does not go ahead and satisfy the data fiduciary that it's ensured compliance with the provisions of the DPDP Act and the rules. That, in a nutshell, is what it is. You see, it's a common boat. They'll all both either sink together or they will swim together. So it's not a question of that my role is slightly slated less under the DPDP Act, so I'll do less. Sorry. In practical business terms, if you want business, if you want to be protected, then putting these things will be very much in place.
That's a very important point that you brought out. If you want business, you better align with the act, right? I think that I see it as a boon rather than a bane, not having put obligations on the processor, rather giving control to the data fiduciaries to be able to ensure that the provisions flow down to the data processors. Thank you, sir. And also, you brought out another important point, that the data protection board should be coming out with certain guidelines, which is very important as well. Like the European Union, the ICO, and the EDPB guidelines that come out very often, and to the fiduciaries, their controllers and processors. So the next question to Mr. Sachdeva, it's now I think the industry has beaten consent a lot. So, but still, we want to call the consent part out. Do you see there's a consent fatigue? I think one of the key lawful basis of processing under the DPDPA is consent, right? So, are you going to see, or are you suspecting there's going to be consent fatigue in the provisions of the act, in the implementation of the act, especially with the consent manager coming into the picture, right? And the fiduciaries need to start aligning with two or more consent managers apart from their consent management system. So, is there going to be consent fatigue that's going to be built up, sir?
Thank you. Important question you have raised. Before I come to consent manager, we need to see the definition of consent under the Act. Now, Act defines consent. It must be freely given. It should be specific, informed, unconditional, unambiguous, and clear affirmative action. which means every consent shall be accompanied by or preceded by a notice given by a data fiduciary to data principal, and this notice must be clear and in simple language. Data fiduciary must state the purpose of processing personal data, and therefore, when he is obtaining a consent, he will have to go by the rigors of the Act. Now, there are deemed consent principles also laid down under the Act, and this is the legitimate use, where a person has given a voluntary, giving of personal data, anything for benefit of data principal, for issuance of any license, certificate, or permit based on use of previous data, anything which is required for the state, and that is for under the law or on the interest of sovereignty, for compliance with any judgment, decree issued under any law, for medical emergency relating to health of the DP or any other person, for medical treatment to any individual during an epidemic. These will be the cases where it will be deemed consent or legitimate use, and you don't need to take the consent from the data principal. Now, coming to the data consent managers, which you have raised as an important issue, the DPE defines a consent manager as a person registered with the board who acts as a single point of contact to enable a data principal to give, manage, review, and withdraw the consent through an accessible, transparent, and interoperable platform. What does it mean? So, consent manager will have to be registered. He will require to obtain registration from the Data Protection Board. Second part, he shall be subject to technical, operational, financial, and other conditions that may be prescribed. And third, he shall be accountable to data principals. The introduction of mechanism of consent managers. Now, what is the purpose? This enables a fast and efficient means of achieving this by bridging the gap between the data fiduciary and data principal. The use of consent manager benefits both data fiduciaries as well as data principals. This improved efficiency of consent management also improves the overall speed, security, and efficiency of personal data flows. Another benefit of use of consent manager is that they will assist data principal in exercising their right of grievance redressal with more ease and efficiency. DigiLocker is a prime example of the possibilities for quick adoption of this facility. The relevance of consent managers is likely to increase significantly over the next years as they act as conduits for more and more online transactions and e-commerce. I think we will see more startups coming as consent managers. But I think one caution where consent manager is acting, those activities will have to be clearly defined so that consent managers do not fall under the ambit of data processing or data processor. So I think that part we will have to have a clarification in coming years, or maybe the 18 months period, how that the consent manager and the data processor will have to be segregating their roles. Thank you.
Thank you, sir. I think you laid down a very clear articulation of what consent is and how it kind of portrays in the Act. So I'll move on to the next question, Talish. This one is for you. Very different question. I'm sure many of you must have heard about data principal obligations. This is the only act across the globe. Approximately around 120 to 140 countries across the globe either have data protection acts or are coming out with data protection acts. India's DPDP is the only act that actually throws an obligation on the data principal. So meaning to say, if I put a frivolous claim or give incorrect information, I can be fined for a sum of 10,000 rupees per instance, right? So typically privacy laws are to give right to the data principal or a data subject, but having an obligation on the data principal and a fine associated to it, is that actually going to hinder data principals to exercise their rights? That's my first question. And second thing is, how do you think it will play on data principals? On the hindsight, do you think it's also a good idea to have this obligation and the fine? Primarily because if you look at Europe, which is extremely high on providing rights to the data principal or data subject, there are a lot of rogue DSRs. I mean, this word rogue is from the European Union. Right, I'm not making it up, but they're called rogue DSRs, meaning to say if there's a disgruntled employer or a disgruntled somebody, they just raise a data subject request, and that takes a lot of money to fulfill. So, Ms. Talish, what are your views on this? Is this actually
So,
going to be a deterrent,
yeah,
and or it's a good thing?
that's actually to me one of the most exciting parts about the act. And because going back, the act has been around for a bit longer than the rules. And to me, every time I've examined it, the line from Spider-Man comes in: with great power comes great responsibility. And therefore, when we are looking at it, I think the step back is, let's also look at what sections 11, 12, 13 and 14 give to the data principle. And those are far reaching, including being able to change information, including information about identity and other things. And when you are to look at section 15 in its entirety, essentially outside of safety, security, sovereignty, it is only subsections B and C which talk about a responsibility to ensure that there is compliance that is there to all laws at that point in time, as well as no impersonation should take place. Therefore, what is there is a safeguard. And I know that there has been a fair bit of excitement for some of us who deal with the questions of rights of individuals vis-a-vis the online ecosystem that has come up and the generative intelligence ecosystem that's coming up. But the other part to it is that these are merely safeguards. So I actually don't look at it. I think so far as the lawmaking went, I think the GDPR experience was taken on record, because there is a deep crisis that we also have. Let's also acknowledge that the EU GDPR rules, the size of population is really small. Ours is a much larger size. Ours is also without being a fully integrated market, we have had cell phones long before reach the last mile connectivity. And with that, the internet reached the last mile connectivity often before essential services. Therefore, there is also that risk that was felt in terms of data impersonation. And that is what has been dealt with. So essentially, it is a system of care that has been introduced. And if you look at the language of the penalty that's imposed, it also says a fine that may be up to 10,000. So you see that itself is also left on to the board while it's deciding. So I don't see that as a penalizing regime. I mostly see it as a disincentivization for rogue elements to block the system down, wherein there is a lot of compliance that is being called for. There's going to be a lot of audit mechanisms that would be there. There's an entirely new processes that have come up in order to be able to safeguard one's right to privacy on the online persona. So this is a very minor part of it, but I think it's a step in the right direction. And eventually, I also see the board being able to lay down far more expansive definitions towards section 15, because impersonation, yes, but for all the other elements, given of course our geopolitical dangers also that are in existence in the system, I think it is something where we can turn around and say that this is not in that sense taking away from civil rights and liberties, instead ensuring that there is a concept of balancing the rights with certain responsibilities.
Thank you. I think that's a very good point you're bringing out. It's not a deterrent, rather, it's more accountability and responsibility that is shared with the data principle. Right, Amit, this one is for you. The next one. This is a global problem, right? Data retention, deletion of data. So the act actually calls out you need to delete your data once the consent is withdrawn or the purpose of processing is over, right? Whereas there are certain other obligations of other laws in the country, such as RBI guidelines and so on and so forth, that mandate you to keep certain data for a period of time. Beyond that, there are certain government organizations that come back to companies to be able to want to seek for data beyond the retention timelines quoted by RBI. Like say 7 years is RBI for financial data, but an example is Provident Fund. They come back after 10 years, 12 years, 13 years, right? So what is your advice to organizations on looking at such scenarios? Should they go hard and fast guideline oriented, like look at RBI, look at Aadhaar Act, look at several other acts, and then decide on the timeline for data deletion? Or should we keep the aspects of government agencies coming back for legitimate reasons, not for any other reasons, and come up with a much higher timeline to facilitate everybody together?
No, thanks for that question. And I think it's one of those really interesting pieces where the law itself, on one hand, gives you very clear retention timelines, right? It says for certain categories, it lays it out. It says 3 years you're expected to retain. And in general, everyone should retain for 1 year, because I think that's coming from the perspective of, law enforcement requests coming in for data. I think for organizations, it's hard to give a blanket answer, but what I'll try and say is, what is that path to balance, right? Where, like you rightly said, there are government agencies which could come 7, 8, 10 years later. Or there could be legal obligations which require, for example, under the RBI requires you to keep, your company records, or even the Companies Act requires certain records to be kept for a longer period. So the mindset needs to change, right? Like, one, you cannot be retaining on that off chance that it could come in handy later. We might be asked. I think there needs to be that mindset change that needs to come in, and what that requires is essentially a mapping exercise to be done, right? One is, what is the purpose for which I have collected? Like, very clearly tied to that purpose, you have a retention schedule around that. Over and above that, you then overlay the legal obligations that are at play. And with that, you get a sense of, okay, what are the additional periods and what are the kinds of data I need to maybe perhaps retain for a longer period. So that retention schedule becomes a very key part of this, and this mapping of both purposes but also legal basis. So you split that exercise, and so that does one part of it. The second part is, even if you're choosing to or you're required by law to retain certain amounts of data for longer than what the DPDP expects as the right retention period, then you'll have to find some ways of maybe putting those in an archive. So you're retaining it, but you're not actively processing it. I can't justify sending marketing communications to a customer who's not used my service in the last 6 years. It makes no sense. But yes, for say purposes of limitation, because there could be a dispute that customer has with me. So for 3 years, I will retain it, transaction records for that purpose. So there I'm storing it in an archive. So there's that segregation between active processing and archiving. And one more thing to kind of bear in mind is also downstream, if you're employing any vendors, it becomes very important to also the same processes that you had in place for for your confidentiality obligations, non-disclosures, that at the end of a relationship or at any point, you need to make sure that your vendors have also followed the retention schedule that you've given them or have actively deleted it. So superimpose some of these incremental data protection obligations now on processes that you might already have in place, and that's a good, happy kind of outcome where you're achieving that right balance.
It's a very apt point that you're bringing out. Many a times the vendor contracts are terminated by the procurement teams, right? And they pretty much forget what data the vendor has about you, right? The termination is more on the contract and the revenue or the money that is going to be given, but not on the data. That's very important to bring out. And I think another important aspect that you brought out was segregating the data and then putting the retention timelines accordingly, which will be more effective. So I'm going to shift the panel now into AI, right? Mr. Duggal, this is for you. I would want you to respond to this. Well, the Indian AI governance guidelines that was rolled out close to a month ago, actually calls out there is no need for an AI Act, right? It has around 7 sutras they call out, which is very much in line with the responsible AI principles. But they very clearly call out there's no need for an AI Act, and also say the relevant sectoral agencies should take the lead on regulations. Whereas they have come out with a structure on who's going to govern and so on, very clearly called out structure. But the point I'm trying to make is, wouldn't this actually end up becoming an after the fact act? Because these sectoral regulations and the other regulations will kick in when something happens. If I had an act earlier, I would have taken into account the nuances to not reach there first, right? While there are guidelines, but there are no obligations, there are no penalties for it. So what are your views on this, sir?
Well, with utmost respect, I completely disagree with the recommendations given in the AI guidelines. Why? Because you cannot keep your eyes closed at mid-noon and think that the sun does not exist. You have to open up your eyes very, very quickly. The world is not out of its mind to come up with dedicated laws on artificial intelligence, whether it's the European Union, whether it's China, El Salvador, South Korea, Japan, Hungary. So to say that, look, we in India, we are good with our existing laws and we don't have a new law on AI is nothing but shutting your eyes to the ground reality. The ground reality is that India will have to very quickly come up with a very detailed, comprehensive legislation on artificial intelligence. Why? Because the Information Technology Act 2000 is thoroughly incapable of dealing with aspects pertaining to AI. Further, the Bharatiya Nyaya Sanhita has never been drafted keeping in mind the AI paradigm. So, trying to just justify that, look, our existing laws are the best and we don't require anything is nothing but closure of an eyes to an inevitable thing that's going to be happening. I believe India has to lead from the forefront. India is a natural leader of the global south. And what we do today will become the benchmarking standard for the world. So India will have to very quickly look at issues pertaining to accountability, transparency, liability, and even personhood. I'm of the strong opinion that India will have to grant first conditional personhood to AI and ultimately full personhood to AI. Why? Because the entire issue of accountability and liability is connected with the issue pertaining to legal personhood. And at the top of it, when you look at the latest trend that's now come from Japan and Hungary, the focus is turning on to completely different. Today, the narrow AI is becoming more intelligent. Next year, you have the AGI coming in. The year thereafter should be the year of super intelligence. Super intelligence, which is going to supersede the cumulative intelligence of humanity as a race. Now, here we are looking at such humongous existential issues, and we are all out in a cocoon to say, hey guys, our laws are the best, we are the best, and our laws will suffice. Our laws are an utter failure in the face of AI, and the quicker we start realizing it, the better it is. Just having these AI guidelines in the form of the draft IT Amendment Rules 2025 is not going to serve the main purpose. Why? Because the primary issue of deepfakes has not been addressed by the primary legislation. And no amount of secondary legislation can go ahead and supersede the primary legislation. So we have some intrinsic problems. I think in that regard, we've started something known as the International Artificial Intelligence Legal Framework Initiative, where we give an a la carte menu of legal principles to governments saying you want to come up with a law on AI. We can choose your legal principle depending on your national interest and come up with a new law. So laws are coming in. You're saying that you don't require laws is just an indication of the fact that you're closing to your eyes to the fact that the last train has arrived on the platform and you are still not decided whether you want to get on the train or not, because you don't know when the next train is going to come. And I'm very sure by the time the next train has come, you've already lost the battlefield. We have lost a lot of previous battlefields in the times of history, including after independence. I think we need to seize this. Even when I look at the guidelines, I look at various legal issues that they are highlighting, but they're saying, oops, this is okay, but no, our laws are good enough. I mean, it's time for us to be more pragmatic. Let's look at the examples shown in the European Union AI Act. Let's look at China. China has come up with 3 laws on artificial intelligence, including a new law that's come from September 2025, saying, guys, you will have to now label AI content. You don't do that, you go to jail or you face unprecedented fines. Here we are saying we will only give a notice of 10% of the total content. Where is that 10%? Who's going to give that particular notice? Who's going to incur the cost for that? And ultimately, how will you implement it both within India and outside India? Most of the AI providers are located outside the territorial boundaries. I've been telling the government it's time that you will have to come up and adopt this concept of artificial intelligence sovereignty, where you will have to say that my sovereignty extends not just to my territorial boundaries, it extends to all AI, whether located in India or not, which is available on computers and computer systems located in the country. In addition, it will also include the right to go ahead and have sovereign large language models to protect your national interests. So a lot of work to be done. With utmost respect, I disagree with the guidelines, and I think time will only tell us what is the best way we can go forward with. Thanks.
Thank you, sir. Very well articulated. I think I agree. I agree with you. I mean, I think it should be beyond guidelines. Guidelines is self-regulatory, and then if I don't regulate myself, there's no penalty for
Guidelines
it. So,
have no danda of the law.
yeah, exactly.
And in our country, without the danda, nothing works.
Exactly. Yeah, very true. Mr. Sachdeva, the next question is to you on AI. Several companies are adopting AI. I think in the previous panel also there was one articulation saying we are in the AI race. It's really the AI race. I mean, even if you don't want AI, you want to use AI because you want to tell you want to use AI, right? Having said that, there is a lot of usage of open source LLMs and closed source LLMs and various types of LLMs. Even the authenticated LLMs by large companies are also purview to this point which I'm calling out. So I'm sure all of you agree the AI models have been built over time by scraping data across the internet, right? Which could include copyrighted information, intellectual property, personal data, and so on and so forth. And there are, especially on open source LLMs, there is very limited guardrails put around such scenarios. So, what is your advice to companies which are actually working on such LLMs and such models that are being used to develop AI systems and they deliver services to their customers? And in the midst of all this, they breach a copyright law or use somebody else's intellectual property.
Important issue. I think when we are dealing with the generative AI platforms, two questions, and those are the important questions one has to keep in mind. Who owns the content that generative AI platform create for you? Who owns? That's the first question. Second, uncertainty about ownership of the AI generated work. Today also there is no clarity. We all are using AI in the belief that AI content is, all protected, it is compliant. But at the end of the day, if there is a non-compliance, it is going to be on you, not on the AI, the generative AI company, because you will be answerable how this particular piece of information was being used by you. So the second issue, while this is when we are using in India, and I think it is coming in the entire globe, legal system is being asked to clarify two things again. Bounds of what is derivative work under the AI. What is that derivative work? How it has to be defined. Number two, what is the interpretation of fair use doctrine, which allows copyrighted work to be used without the owner's permission? Now, most of the time, AI is being used on the premise that whatever information or content you are going to get from the AI, that is legally permissible. Maybe there is a violation of the Copyright Act. Nobody knows. There is a violation of third-party rights. We don't know. So I just did some research before this topic was allotted this morning to me, and I found something very interesting, and I'll share it with you. There's a case of Anderson versus Stability AI. There were 3 artists who formed a class to sue multiple generative AI platform on the basis of AI platforms using their original work, and as a result, this was seen as an unauthorized derivative work. I think, and they succeeded because the information which finally was culled out, and this could be seen that there's an imaging service provider, and this was the unauthorized use of the photos violating copyright and trademark rights. It had in its watermarked photograph. So the AI which was generating the photographs was not, but it was copying the imaging services of the earlier AI work, and this was the watermarked photographs of some other artist which was being reproduced through the AI model. In 2023, similar case was filed where AI tools using data which will be seen as unlicensed work, and these are all in US. This US case laws are there where the liability was then fixed onto the person who was using the AI tools. Now, I also came across one health case law. This is versus Dinerston versus Google. Health Insurance Portability Act was violated in this case when healthcare organization granted access to patient medical files for AI data company DeepMind. Data was used by the Google to train its AI for proposed potential patent. When it came to the notice that the patient files, and those were the medical files, those were given access without the consent. Obviously, no consent was taken from the patients. This was a case which was highlighted, and Google was sued for millions of dollars, and the people succeeded in this case. So coming back to the issue, I think when we are using today AI, one has to see whether the company which is going to be providing you, or you are taking the AI content, that tool should have the models which should be in compliance and properly licensed. from the content owners. And this should not be something where you see a violation of the copyrighted work and they then take the interpretation of fair use doctrine that it allowed them to use a copyright work without the owner's permission. So I think AI content, while we are using AI, one has to also check whether the information which is being derived is correct and is not in violation of the third party rights.
Thank you, sir. I know the time's up. I'll just give one minute to the three panelists because if they have come prepared, I don't want to deny them the second chance. So we'll start with you, Talish. Talish, again, keep it just 1 minute. What are your views on the importance of AI testing AI systems? Because that becomes very critical component using
Yeah.
third-party tools.
Yeah.
I think, like Mr. Sachdeva was saying, you can't rely on somebody else's content but you are the owner of the content.
Yes. So basically, the advice that we go out and give our clients in this, number one, when you're talking about testing, look at global best practices, because as Mr. Duggal before me pointed out, this is an entirely new world and an entirely new beast. And therefore, to turn around and say, well, this is what is applicable in India but is not applicable, you see those rules are applicable there, China's territoriality, that those functions are basically collapsing. So while doing that, first run across a global compliance to see whether you are following the best practices internationally, simply because technology itself, generative intelligence technology itself, is moving at a much faster rate than you and I can imagine. That's number one. Number two, have a very, very robust, transparent system. Ask for sources. Get down to the basic principles of any research. Go back to the source, ask for them, and ask them to give those undertakings that are there as to what their compliances are about. But I think overall, one of the things that I found very useful in the long term when we are advising and looking at the best practices that come in is to have risk assessment. Regular risk assessment to classify AI systems. Then you're looking at also the ethical principles that are involved. So all of those, when combined together, tend to make a fairly robust system. But again, it is nowhere in keeping with what would be much better if there was a established legal system saying this is a checklist, go on for it. Because currently, like the Wild West, everybody is following what they imagine are best processes with very little understanding of what liabilities might arise should it be taken to court.
Sure, thank you. I think a very important aspect that you brought out was monitorability, which very seldom is thought about because everybody is thinking of deployment. Thank you for that. Amit, this question is to you. What are the, again, 1 minute answer, what are the contractual obligations you advise when you are actually delivering AI systems to your customers?
No, sure. And if you'll give
I know it's a huge topic by itself, but I've given
No,
you only 1 minute.
and I'll tell you where the need for strong contracts comes in, right? Like across the value chain, you have a number of players. You have the model developer, like someone who's created the model, a deployer, someone who might be integrating it in your systems. You're using it with your end customers. There's that entire value chain, and there's a lot of talk around a shared responsibility framework that should be developed. But end of the day, regulators aren't necessarily viewing it that way. They look at, if you see the RBI's outsourcing guidelines, for instance, they say regulated entity, I will catch your neck. You use what you want to outsource certain parts of your processing, to an AI, you want to do it for any purpose. I'm going to eventually come after you. And therefore your contractual safeguards actually become very critical in that context, right? Regulators are eventually going to come after that point of at the point where it's interacting with real world people and that. So up the value chain, it becomes very important to push certain responsibilities up that value chain, and depends on where you're sitting in that. So, a model developer will need to tell you that what your use case is, this is a fit for purpose. That representation warranty becomes very important. We were talking about IP earlier. Is there going to be IP infringement? So is your data set trained in a way that allows, is going to likely result in an IP infringement, and that also becomes a market differentiator. So certain Gen AI tools like Adobe's Firefly was one of the first to come out and say we will indemnify from any downstream claims of AI infringement, like IP infringement. So those indemnities also become critical. So it'll be a combination of strong reps, indemnifications, but also your ability to audit and verify this. You can't take everything you hear at face value. So up the chain, your ability to audit, ensure that things are being done according to what has been promised to you, become critical. I will just take the last 5 seconds to respond very quickly to Dr. Duggal. I'm not sure I agree with the need for a general purpose AI law. I think the regulators, at least this governance guidelines, say very clearly that they've done that mapping of risk and see for a large part of those risks, existing regulation does hold the field. Where there's a gap, you might want to step in and regulate or tweak existing regulations, because we should also be mindful that as a country, regulatory capacity is also something we kind of overlook when we are saying let's bring in a new law. Do we have the capacity to necessarily implement it in a meaningful way? It's better not to have a law that you can't implement well, rather than forcing one on the books. Is just and it's something we can disagree on, but just wanted to respond to that.
Last question to Srinit. What are your views on, or maybe some examples on the biggest mindset mistakes that AI leaders have? Maybe if you can throw some light on that.
Okay, there are way too many senior people sitting here, but whatever I have experienced in my short corporate career, a lot of times AI is being seen as a technological tool or project instead of a change in complete mindset. So what I would love to see is all organizations, including myself or my organization, I work for a Fortune 500 company, and what we should be doing from a leadership perspective is that view AI as a capability, exactly like you see marketing, like you see sales, like you see finance, not just as a technological project. And invest in platforms, absolutely, but invest more in people. These are the very few people who will ensure that your platforms are a success and your companies a success while using AI. So if I'm in a leadership position, I cannot just say, okay, AI is just a technical project and I'll look after the intricacies later. I cannot allow my ego to sort of, my inflated ego to write checks which my career can't cash. I need to be very, very sure about what we are doing as an organization. So if I just have to put it in one line, AI is a mindset change to embrace. It's not just a technological tool. So let's just accept it as it is. Thank you.
Wonderful. Thank you. Thank you to each one of you for your wonderful sharing of experiences and your points of view. Well, with that, I think we have really run out of time. I would like to end with one note. Data literacy and AI literacy is, I think, one of the key and most important aspects for the world today. Because if you don't know how to use your data, I'm pretty sure all of us in this room would have given our phone number for 10% more discount in some time or the other, right? Even I have done that. So even if you don't lift, I know you have done it too. So, and similarly, AI, the usage of AI, we may find a wow factor, but you should understand why you're using it and what happens behind the scenes. And I can quote several examples, but then again, no time for it. But again, thank you very much for the wonderful panel and the kind of points of view that was shared. I hope it gave an insight into an overview of the DPDP Act rules and AI guidelines that we were wanting to intend to talk about. Again, thank you very much for your patient hearing. And with that, thank you again.